And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
The average person assumes a traffic stop is the easy part. After all, you're not the threat. You have nothing to hide. You are the good guy, right? That mindset is exactly how hundreds of people every year turn a simple 10-minute stop into a 5-figure legal nightmare. They get arrested, they lose their permits, they rack up massive legal bills, all because of one bad answer or one rushed movement at the roadside. I am not here to scare you. I am here to give you 4 exact, legally crucial phrases that could save you in court, on the roadside, and in every legal system that is silently waiting to trip you up. These are not magic words. They are constitutional boundaries. Let's break down these phrases one by one so you stay protected, stay legal, and stay in absolute control, no matter how routine the flashing lights feel at first. Phrase number 1, I'm not sure, officer. The trap question. Let's start with a question that feels simple, but it gets drivers, especially those lawfully carrying, into trouble more often than you might possibly imagine. It is that first, seemingly innocent question most officers ask when they pull you over. Do you know why I pulled you over? On the surface, this sounds like small talk. It sounds like the cop is giving you a chance to apologize and move on. But for the purpose of a legal record, that question is actually a sophisticated legal trap. The officer is not asking to be friendly. They are asking because they want you to commit to a narrative before they have even told you what violation they believe you committed. And if you put your own words into the officer's written report, prosecutors can and absolutely will use them later if things go sideways. Think about the psychological pressure here. You have been conditioned your whole life to be helpful. You want to be honest. You want the interaction to go smoothly, so you launch into an explanation. I think I might have been speeding a little bit. Maybe I didn't come to a complete stop. I was just checking my phone for directions. Every single one of those little phrases sounds innocent to you, the driver. But here is the harsh reality of traffic and criminal law. That comment becomes evidence. It becomes part of the officer's written account. If there is any escalation, a sudden movement, an ambiguity in your paperwork, or a call for backup, that written account will be pulled apart by lawyers who want to argue you admitted guilt before your constitutional rights were even fully at stake. Now, add a firearm into the mix. Even if you have a permit, even if you are confident you did nothing wrong, your words can indirectly shape the officer's perception. If you start explaining or guessing before you even know what the citation is for, the officer might interpret that as nervousness, evasion, or an admission of generalized guilt. They may put it in the report. Motorist appeared evasive, or gave inconsistent answers to initial questioning. That kind of language is exactly what prosecutors use to justify search requests, review your ability to hold a carry permit, or even escalate to more serious charges in specific jurisdictions. Let's look at the legal context most people ignore. Courts have repeatedly stated that an officer's written report, especially one supported by the driver's own statements, carries tremendous weight. Statements you make at the roadside can be used under both traffic and criminal law. In historic cases we've seen reviewed by law advisor, judges have upheld citations or arrests, not necessarily because of what the officer saw, but because of what the driver willingly admitted during questioning. Your words can hurt you far more than your actions in that moment. That is not a dramatic catchphrase. It is the legal reality. Wait, let's look at that again. This is not about playing games or lying. It is about protecting yourself by not volunteering information before you fully understand what the allegation is. One of the most consistent mistakes I see in traffic stop interactions, especially those involving concealed carry, is people attempting to justify their behavior. They think, I'll explain what I was doing so the officer knows I wasn't dangerous. But until the officer tells you exactly what they believe you did wrong, there is no factual basis for you to start explaining. That is why your first, best, and safest line has to be, I'm not sure, officer. Saying that takes the pressure off. It does not sound hostile. It does not sound evasive. It sounds neutral. It tells the officer that you are willing to cooperate, but you are not going to admit to something before you know what it is. It also legally removes the chance of creating a written admission of guilt in the report. You are just responding to a question with the truth. You do not actually know why you were pulled over until the officer tells you. Consider this scenario. An officer pulls someone over for rolling through a stop sign. The driver immediately says, I thought it was a 4-way stop and I looked before I went. The officer writes in the report that the driver failed to stop completely and admitted uncertainty about the stop procedure. Later, in a permit review hearing, that admitted uncertainty becomes part of the narrative used against the carrier as evidence of recklessness. If the driver had simply said, I'm not sure, officer, there's nothing for the officer to put in the report other than the stop facts themselves. That is the difference between a neutral report and one that becomes self-incriminating evidence. Learning how to say less while still cooperating appropriately is a high-level skill. It is not arrogance, it is not distrust, it is self-protection, and it is exactly the strategy responsible citizens need to master before they ever find themselves looking into their rearview mirror at those flashing lights. Word to phrase number 2. My license is in my wallet. I'm reaching now. Stop the furtive movement claim. You could be the calmest, most responsible person on the road, but if you move wrong at the wrong moment, that entire perception disappears in a puff of smoke. When an officer walks up to your window and asks for license and registration, most people instinctively reach without thinking. It is routine. We have all done it. But if you are carrying, especially concealed, that one movement without warning can instantly shift the tone of the entire stop from routine to high risk. From the officer's perspective, they do not know what you are reaching for. All they see is a hand disappearing toward your waistband, glove box, or center console. And that is when the threat perception kicks in. In legal terms, this is what is known as a furtive movement. Under foundational rulings like Terry versus Ohio, and supported by decades of Fourth Amendment case law, an officer is absolutely allowed to escalate a stop, conduct a limited search, or forcibly remove you from the vehicle if they believe your behavior appears suspicious or immediately dangerous. And yes, they can absolutely write this into the report. Driver made an unexpected movement toward the waistband, or individual reached quickly and failed to notify. That kind of phrasing gives them immediate legal justification for a pat-down, a vehicle search, or a call for additional backup. You may think you're just trying to hand over your license. They may think you are pulling a weapon. That is why narration is not just helpful, it is protective. The moment the officer asks for documentation, your first response should be verbal, calm, and crystal clear. My license is in my wallet. I'm reaching now. Then, and only then, you move slowly and deliberately. That line buys you space. It signals to the officer that you are aware of their safety concerns. You're not hiding anything, and you're not about to make a mistake that gets interpreted as aggression. Even in duty to inform states where you are legally required to disclose that you're armed, this verbalization step comes first. You do not just blurt out, "I have a gun," while reaching toward your storage area. You narrate the motion, give context, and let the officer remain in control of the pacing. Remember, law enforcement is trained to prioritize safety over assumption, and if you startle them, you lose control of the encounter immediately. Once your license is out, do the same thing for your registration. That's in the glove box. I'll grab it next. Wait for acknowledgement, then move again slowly. Every single motion should be preceded by a clear verbal explanation. If they do not respond or acknowledge your narration, say it again politely. Make sure it is on record, whether that is body cam audio, dash cam footage, or just their mental log of the stop. Once you have handed over both items, both hands must go back on the wheel, open, visible, still. That simple act alone can lower the temperature of a stop by 50%. It tells the officer that you are not a threat, you're not going to fidget, and you're not making them guess about your next move. This is not about paranoia. It is about documented control. Your control over how this interaction gets written down, remembered, and ultimately defended in court. Because if something does go wrong and that stop turns into a courtroom issue, what gets said, what gets recorded, and what gets written in the report is everything. There have been dozens of real cases where drivers were charged with felony menacing, failure to notify, or even brandishing, simply because they reached too quickly without saying anything first. Some were never intending to touch their firearm, some did not even remember they had it positioned where the officer could see it. But once the officer's narrative frames it as a threatening movement, the legal burden shifts entirely to you to prove that it was not. If that happens, your calm voice saying, "My license is in my wallet. I'm reaching now." Once this can be your single best defense on the body cam, in the transcript, and in front of a jury. It shows clear intent, it shows discipline, it shows awareness of legal responsibility. Silence, on the other hand, can only be filled with assumptions. And in these cases, assumptions always hurt you. This entire step may take an extra 5 seconds, but it can save you months of legal stress, thousands in attorney fees, or even your right to carry it all. Build the habit of narrating your movements before making them. Because one fast motion, misunderstood, can turn a routine stop into a weapon charge. Your paperwork is not the only thing you're handing over. You are handing over the story of that stop. Make sure it is one you are proud to have recorded. If you are finding this analysis helpful, please take a second to like this video and subscribe to Law Advisor. It helps us keep these deep dives coming. Now, back to the case. Phrase number 3, I do not consent to searches. The Fourth Amendment line in the sand. The officer hands back your license and the conversation seems to be wrapping up. Then it usually starts with a casual question. Where are you headed? Just running errands. Then comes the real hook. You don't have anything illegal in the vehicle, do you? You don't mind if I take a quick look, right? Most drivers panic here. They desperately want to seem cooperative, so they say, sure, go ahead, thinking they have absolutely nothing to hide. The second you say yes, you have just waived your Fourth Amendment protection, and you have given full, unmitigated permission for that officer to search your vehicle, your bags, and anything in reach. No warrant, no probable cause, just your own words opening the door. This is where good people, especially gun owners, make a critical mistake. They think saying done, no, is enough. It is not. In court, vague or weak responses like, no, I guess not, or I'd rather not, are often interpreted as passive consent. If you hesitate, ramble, or sound uncertain, the officer can still justify the search. Once you have consented, even passively, anything found becomes admissible evidence, even if it should never have been found at all. That is why the exact phrase matters. You say it clearly, calmly, and without attitude. I do not consent to searches. Those 5 words create an ironclad legal boundary. They tell the officer, and any future judge or prosecutor, that you asserted your constitutional right not to be searched without cause. It is respectful. It is firm. and it puts the responsibility back on law enforcement to follow the law and establish probable cause. Now, why is this critical for gun owners? Because you carry gear, a spare magazine, a holster, maybe a backup knife. None of that is suspicious by itself, but what is legal in your county might be highly illegal 2 miles down the road. A magazine that is perfectly fine in your home state could trigger a felony charge across state lines. Ammo storage laws vary wildly. Transport laws vary. Even something as simple as having a locked box in the wrong spot can raise questions you did not expect. I have seen actual cases where a search led to totally unexpected charges. A legal gun stored under a towel was cited as unsafe transport. A locked pistol in a backpack was flagged as improper storage because it was not declared in a duty to inform state. One driver consented to a search and was charged for having a folding knife that exceeded the city's blade length limit. He had no idea that law even existed. None of these situations involved bad intentions. These were all legal carriers who simply did not know the rules had changed from town to town. But once the search happened, those gray areas instantly turned into criminal charges. And they were the ones stuck proving their innocence. Ambiguity is your enemy. If your answer is vague or unsure, it can be twisted later. Courts have consistently ruled that unclear or soft answers are treated as consent. Silence is no protection either. If you shrug, say nothing, or freeze up under pressure, officers are often allowed to take that as a green light to proceed. So, your line must be clear and confident. No debate, no emotion, no confrontation. Just the facts. I do not consent to searches. And if the officer pushes back, why not? What are you hiding? And don't get defensive. You're not on trial. Just repeat it. I do not consent to searches. That repetition is key. It shows consistency. It shows intent. And most importantly, it removes all doubt if anything ever ends up in court. Now, what if the officer proceeds with the search anyway? They might say, "Step out of the car. I'm going through your vehicle." Don't argue. Don't resist. Don't physically block them. That is how people turn a civil rights violation into a resisting arrest charge. Let them do what they are going to do. The crucial difference is that the fact you clearly stated your lack of consent gives your lawyer something powerful to work with later. If the search turns up anything and your denial of consent is on camera or in the report, your legal team can fight aggressively to have that evidence suppressed because it was obtained through an illegal, non-consensual search. In most cases, once you clearly assert your rights, the officer will drop it. If they do not have probable cause and you have not given consent, they cannot legally continue. But do not break halfway through. Some officers will use silence and time to pressure you. They will keep chatting, saying things like, "It would be faster if you just let me look." Stay calm, repeat your line if needed, and wait it out. Your job is not to make the stop easier. Your job is to stay on the right side of the law while protecting your rights. You're not doing anything wrong by saying no. You're doing exactly what the Constitution allows you to do, and what far too many people forget in the heat of the moment. Your clarity is not confrontational. It is smart. It is legal. And it could be the one thing that keeps a legal stop from turning into a life-altering disaster. Phrase number 4. Am I free to leave? Your escape hatch. Let's say the stop should be over. The officer ran your ID. Your plates came back clean. Your firearm is lawfully stored. You answered every question calmly, and there's no active violation they can pin on you. But for some reason, they are still standing there. They are still asking casual questions, still probing the conversation, still lingering around your window. At that moment, you are in the single most dangerous part of the entire encounter, the gray zone between a routine stop and something far worse. Police officers do not always slam you with flashing lights and immediate arrest. Sometimes they just keep talking. Casual questions, nervous small talk, requests for a few more minutes of your time. And many people fall right into that silent trap because they do not know when they are legally allowed to go or how to make the interaction stop. That is where this phrase becomes your shield. Am I free to leave? This is not attitude. It is not pushing back. It is a calm, clear legal check that puts the burden squarely back on the officer to either cut you loose or admit they are officially detaining you without probable cause. Either way, it puts the power back in your hands. Let's talk legal foundation. The U.S. Supreme Court in Rodriguez versus United States, 2015, ruled emphatically that police cannot extend a traffic stop longer than necessary to address its original purpose, say running your license and writing a ticket, unless they have clear, independent legal justification. If the reason they pulled you over was speeding, and that part's done, they cannot just linger to fish around or stall until something else comes up. Doing so becomes unlawful detention. And yet, this still happens constantly because officers know most people will not question it. They will chat. They will freeze up. They will worry that asking to leave sounds confrontational. So the conversation just drags on, and the longer it goes, the more likely something slips, changes, or escalates. Now, this is where it gets really strange. The courts will not protect you unless you say the actual words. Judges look at whether you asserted your rights. If you never asked if you were free to leave, the courts may treat it like you stayed voluntarily. That means every minute you remain, everything you say, becomes legally admissible, even if it all stemmed from a stop that should have ended 10 minutes earlier. Timing matters here. You do not ask this right out of the gate. You wait until the officer's questions start drifting from the original issue. Once you sense they have wrapped up the reason for the stop, but they are still probing, still chatting, still hanging around, that is when you ask calmly and clearly, "Officer, am I free to leave?" No sarcasm, no challenge, no threats. You're not demanding to leave. You are asking a legal status question, and that distinction matters profoundly. If the officer says yes, you do not need to explain yourself. You say thank you, and you go. If they hesitate, dodge, or change the subject, repeat the question. Am I being detained, or am I free to leave? That follow-up forces a direct binary response. And once again, you have created a clean, legal record that your rights were being asserted, not waived. What happens if you don't ask? Let me be blunt. The situation can slowly slip entirely out of your control. I've seen actual cases reviewed by Law Advisor where drivers spent an extra 15 minutes in roadside limbo. In one case, a man was waiting patiently while the officer wrapped up paperwork, then got accused of acting evasively when he shifted in his seat. That innocent human reaction was used to justify a full search. No new evidence, no crime, just a long pause, and a human reaction twisted into suspicion. Another case involved a driver who was casually talking about his car and travel plans, all while thinking the stop was nearly done. But a single offhand joke about being in a rush led the officer to delay him further and then call for backup. That delay created just enough justification to hold him until a drug dog arrived. Again, no drugs, no charges, but hours wasted, car searched, and dignity shredded. The pattern is clear. The longer you stay, the more they look. And the more they look, the more risk you face. That is why this phrase, "Am I free to leave?" is not just about getting home faster. It is about reclaiming the constitutional boundary. Officers are allowed to investigate within reason, but you are allowed to leave when that reason ends. If they say no, say nothing else. Do not fill the silence. Do not volunteer any information. You have just triggered legal scrutiny, and anything you say next will be used to try and justify the detention you are already under. That question alone can change the course of everything that follows. Because the truth is, silence won't save you. But one well-timed, legally focused question just might. That is all for today. 4 phrases, 4 make-or-break moments that could decide whether you walk free or face a courtroom. These 4 phrases are not just suggestions. They're the exact legal tools that stop roadside stops from becoming criminal cases. 1. I'm not sure, officer. Shuts down trick questions and prevents self-incrimination. 2. My license is in my wallet. I'm reaching now. Puts your necessary movements under constitutional protection and disarms the furtive movement claim. 3. I do not consent to searches. Blocks surprise searches before they spiral into finding legal gray areas that turn into criminal charges. 4. And the 4th, the most overlooked. Am I free to leave? Is your legal cue to walk away before the investigation extends past its lawful limits. I'm not saying every officer is out to trap you. I'm saying the system is built to use your words against you, so give it fewer words to work with. Set clear constitutional boundaries that courts recognize. Stop casual conversations from turning into felony charges. If this analysis gave you even one new tool, or reminded you of something you needed to hear again, do me a favor. Thanks for watching, and don't forget to like and subscribe for more legal breakdowns. And remember, stay safe, stay smart, and never forget, knowledge is the ultimate defense. I'll see you in the next one.